May it please the court, Michael Franz for the appellant Deborah Bryce. I'd like to reserve 3 minutes for rebuttal.
That will be fine.
Thank you. This is a case about a parcel of real estate that's adjacent to I-75 in Anderson County, and it's also about a long-term billboard lease that was on the property. It was entered into by the party's predecessors in title back in the early 1980s. This lease is essentially what the case is about. Mr. Cry's client, Mr. Partin, he's the current owner of the real property. He bought the property in 2022. And my client, Deborah Bryce, is the assignee and the current holder of the leasehold interest under the commercial billboard lease that's at issue. And Mrs. Bryce is also the owner of the sign face on one side of the billboard structure. The other parties to this case, the estate of Wilford Johnson and the estate of Carl Johnson, they own the other sign face on the opposite side of the billboard that faces traffic coming from the other direction. I want to quickly note first, before I get into the argument, that there was testimony at trial about two different billboard leases, one of them with a 50-year term and one with a 25-year term that was renewable for an additional 25-year term. There was a lot of discussion in the trial transcript about that, but I wanted to point out, for purposes of this appeal, the only lease that matters is the second lease. The trial court found that the second lease replaced and supplanted the first 50-year lease. We haven't appealed that conclusion. So at this point, every party agrees that what matters is that second 25-year lease. So as to that second billboard lease, it had an initial 25-year term, started on December 1st, 1983, and the initial term ran through December 1st, 2008. So if it is found that the lease continued in effect for the second 25-year renewal term, then that renewal term would run through December 1st, 2033.
Well, legally, does the lease renew for 25 years, or is it a month to month or year to year, or how?
Our position is that it was renewed for the 25-year term, and the lease.
Wasn't there a condition to the renewal? Then you have to apply for
the lease says that.
Was that requested?
Yes, Your Honor. The way to exercise the renewal of the second 25-year term is to send written notice. The lease says that it had to be sent 90 days before the expiration of the original term. And just to be clear, there was no evidence presented at trial that this written renewal notice was ever provided. And so the trial court treated that as dispositive and said the notice wasn't given, there's no evidence that the notice was given, and therefore the lease expired at the end of the first.
Was there any notice that a renewal was granted?
Our position is that the parties treated the lease as if it was renewed for an additional 15 years. The plaintiffs remained in possession of the
We're talking about property here. Doesn't that have to be in writing?
The lease said that it had to be in writing, but our position is that that was waived because the parties acted for 15 years as if the lease had been renewed. No one took any action to assert that the lease had been non-renewed, that Mrs. Bryce needed to leave the property because she no longer had a leasehold interest. She continued to maintain the billboard and continued to rent it out for 15 of the 25 years of the second 25-year term.
She continued to pay the rent?
She did not pay the rent. There was
Okay.
no evidence at trial that the rent was ever paid. Our argument on that is that the rent was nominal consideration. The lease says that the rent to be paid to the landowner was, during the first 25-year term, $10 a year. During the second 25-year term, $20 a year. So that is such a insignificant amount of money. Our position is that it was nominal consideration, and therefore it didn't matter whether it was paid or not. So the case law on waiver of a written renewal provision in a lease does typically say that that occurs by remaining in possession of the leased property and paying rent. But this is a different situation because there really was no rent that was owed. It was nominal consideration, and whether it was paid or not didn't matter. We cited a case in our brief to that effect. So in our position, the fact that she remained in possession of the property for as long as she did, with no one ever bothering to speak up, and there was testimony at trial that The owners of the property during this time, just to go through some of the history, the owner in the 90s was Josephine Yarber. She passed away in 2001, and at that point, the beneficiaries under her will owned the property. One of them, Mr. James Yarber, testified at trial. He admitted that he knew about the billboard lease. He knew there were issues between his mother, Josephine, and the lessee while she was alive, and he knew about this lease. He knew the billboard was on the property because it was open and obvious. Anyone who went to the property knew there was a billboard there. And yet, Mr. Yarber and the other heirs of Josephine Yarber made no effort to ask for rent, try to collect rent, try to figure out who owned the billboard, try to even make contact with the lessee. Nothing happened during this period of time, and the plaintiffs were continuing to rent the billboard out to advertisers. Everyone just treated it as if it had been renewed. So that's another point with respect to the written notice, renewal notice that's required under the lease. Mrs. Bryce didn't know who to send the renewal notice to because Mrs. Yarber had passed away in 2001. Her beneficiaries owned the property, and they had never made any attempt to make contact with Mrs. Bryce, so they didn't know. She didn't know.
Did she make an attempt to figure out who to send it to?
I don't think there was any testimony of that at trial. I think she just continued
So
doing what
nobody
she was
did
doing.
anything, they just kept going on like they had been?
All parties just continued to go about it as if the lease were still in effect. And so our position is that there were equitable defenses that should have resulted in the conclusion that the lease continued in effect. Waiver, which I've already talked about, and then estoppel and latches. The trial court didn't consider any of these equitable defenses. The trial court just said there was no evidence that the written renewal notice was provided, therefore the lease expired, therefore Mrs. Bryce is a holdover tenant. But that's an unusual conclusion that she was a holdover tenant for 15 years. Our position is that the trial court should have used these equitable defenses that were pled, and I know Mr. Partin's position is that they were not adequately argued at the trial court level, but they were pled in the answer to the counterclaim, and they were discussed in some form at trial. There was testimony presented on each of them, and they were mentioned in the final closing argument. Estoppel and waiver were mentioned specifically by name, and Mr. Lacey, who handled the trial, he made a latches argument without using the word latches. So I don't think that the label of the term latches is necessary to preserve that issue for appeal, because he argued that there was an unreasonable delay in exercising the right to try to remove Mrs. Bryce from the property. That was they waited to do that for 15 years, and there was prejudice to Mrs. Bryce because during that time, there were a lot of things that happened. Documents were lost. The owner of the other half of the sign, R&J Sign Company, that's the estate of Wilford Johnson and Carl Johnson, all of their billboard records burned in a fire during that period of time after 2008. So the records were lost. Mr. Rankin, who previously owned the billboard, he died in 2013, so his testimony was no longer available due to this unreasonable delay. So latches is another route.
The trial court ordered what as to the revenue from the billboard?
Okay, the revenue. While the case was pending in the trial court, Mrs. Bryce had an advertiser on that face of the billboard, and so there was revenue coming in, and that revenue was paid into court pending the outcome of the case. And so the trial court held at the end of the trial that since there was no lease anymore, and Mr. Partin would have been the one entitled to, I guess, put a billboard on the property, even though he didn't own the billboard itself, the trial court found that he was entitled to all the revenue minus $1,300 for the production costs associated with putting the billboard up.
For all the revenue during the time that the suit was pending?
Yes, Your Honor.
Okay.
So, and then that became the
Didn't go
subject.
back any further, or it was just during the time?
It was just the time the
Time the
case was
suit was
pending.
pending.
That's
Okay.
right. And I don't believe Mr. Partin made a claim to the prior revenue. He had just acquired the property in 2022, so he had only owned it for a short period of time when the lawsuit was filed. But the issue of the money paid into court was the subject of a Rule 59 motion filed by our client because there were other costs that she incurred in operating the billboard that weren't compensated. So it was going to result in a windfall to Mr. Partin. He was going to get a bunch of money for nothing but just owning the property, and that was improper. And the trial court found that it was appropriate to hold an evidentiary hearing on the issue of what to do with the money paid into court because of manifest injustice. That was the basis for granting the Rule 59 motion.
Trial court found that the plaintiffs were the owners of the southbound Reed.
The sign, yes, the sign
The
face.
sign, they were the owners of the sign itself.
The sign face itself.
Sign face itself.
And the sign face on the other side is the one owned by the two estates. And then the pole that runs in the middle of the two signs is still owned, in our position, is still owned by Robert Rankin's estate. So the only thing that Mr. Partin owns is the land, and that's it. So after the Rule 59 motion was granted, the trial court revised its ruling about what to do with the money paid into court and also granted Mrs. Bryce the costs of utilities that she had paid out of pocket and a payment for the use of her sign face. Again, she owned the sign face, and also the permit, the Tennessee outdoor advertising permit. So we think that that was also erroneous because the typical arrangement is the landowner only gets 25% of the revenue off a billboard. There was testimony at the evidentiary hearing about that. So that's what we think the result should be.
All right, thank you. You have your time for rebuttal. We'll hear from the appellee.
May it please the court, I'm Phil Cry of the Anderson County Bar, and I represent the appellee Nathan Partin, and I represented him in the trial court. I would like to make my argument in two parts. One with regard to the claimed errors from the judgment and trial itself, and then the second from the claimed errors from the Rule 59 hearing. But first, I think it might not be all that pertinent, but it might be of some help to the court to know a little more about how this arose. The record would establish that in 1983, two brothers, John and Robert Rankin, were getting in the billboard business. They came from a family who had been in outdoor advertising in the sign business, which means like painting signs on buildings, but which their father did for a living. But they were starting in the billboard business. And as part of that, Mr. John Rankin bought the property, the real estate that my client now owns. There were a number of intervening conveyances between him owning the property and Mr. Partin owning the property. When Mr. John Rankin purchased the property, it was with the intention of constructing a billboard on it. And very quickly, there was a one-page fill-in-the-blank lease agreement, which is Exhibit 3, executed between Mr. John Rankin as the landlord and Eastern Outdoor Advertising, which was their billboard business, as the lessee, providing for a 50-year term with rent at $10 per year. And it may not be all that pertinent, but I think it's clear that Mr. John Rankin's benefit from that sign was not the rent he was going to collect, but the money he was going to make off of renting the sign through the sign business. Mr. John Rankin then sold the property that later that year in 1980, the deed says 1983, although it wasn't recorded until 1986, and then the property passed through numerous other owners till it became owned by Mr. Partin. The sign was constructed apparently in 1983. The sign business, the billboard business, was then sold by the Rankins in 1993, 10 years later, to Mr. Philip Bryce and his partner Jack Satterwhite. Then later in the 90s, through some transfers within that partnership, Mrs. Bryce became the sole owner of the sign business. Back in 1983, after the initial sign lease, the lease for the billboard was executed, there was a more detailed typewritten lease, that's Exhibit 4, executed, and it has terms slightly different. It provides for a 25-year term with a 25-year renewal. It provides that to renew, there has to be a written notice within 90 days given to the landlord before the expiration of the first 25-year sign, before the first 25-year term. And Mr. France is correct. There was no evidence that there was ever a written notice of renewal given. The record established that there was really never any rent paid on this sign, as best we could tell. The only money that was paid was a predecessor entitled Mr. Partin was Mrs. Yarber, who died in 2001. She built the house on the lot that is now occupied by Mr. Partin. She had some damages that was to her property as a result of some trees being cut, and the sign company, the plaintiffs in this case, paid her some money for compensation.
Did they pay her rent?
Well, as I recall, the documents that she signed says it's rent, but it appears to have been actually compensation for damages for cutting trees. But
Okay,
that's it,
so-
that one-time
So
payment.
there's no evidence she was paid rent either?
No, Your Honor.
So what we have is a contract with the new renewal provision. Nothing was done by any party.
Nothing changed.
So after the expiration of the first 25 years, what do we have?
Nothing changed. The record was established that the rental activity on the sign diminished in more recent years, and there was a period where there was apparently no rental income being generated by it.
So do we have a contract at all?
No contract, Your Honor.
So what is it? It's just a,
It's a holdover.
well, what does that mean?
It means that there has been since December of 2008, when the original lease expired, a holdover, and I think it would be, our position would be, it was a year-to-year holdover, a tenancy. And what provoked this litigation is,
Was money being actually paid during that period of time?
I'm sorry, Your Honor.
Was money being actually paid for the rental of the billboards? during
No,
that
Your
period
Honor.
of time?
There's been no money paid.
No money paid.
And the only rent provided for in the 25-year lease was how much?
It was, as I recall, Your Honor, a few $100s that was paid to Mrs. Yarber in the latter 90s as a result of some litigation, and then
What did the lease provide for?
during that time period, it would have called for $10 per annum.
And no share of the revenue from the billboard?
No share of revenue for
Just
the
the
billboard.
rent was $10?
$10,
Okay.
which goes back to my earlier point. I think the revenue to the original landlord, who was Mr. John Rankin, who was in partners in the billboard business with his brother Robert, they were both parties to the lease, was revenue to be derived from the leasing of the billboard. In fact, Mr. Douglas Yarber, who was Mrs. Yarber's son, testified at trial, and I think his words were to the effect that the sign it was there and everybody knew it was there, but it was just a problem to the landlord, to the owner of the property. So with that background, the appellant agrees that because the two leases, Exhibit 3 and 4, are inconsistent in terms but cover the same subject matter, the trial court was correct in finding and concluding as a matter of law that the latter lease controlled, and it contains the 25-year initial term with a 25-year renewal, and it's specific as to how it is renewed, which is in writing within 90 days of the end of the first term. And there,
But if the second lease, how can the second lease control when nobody did anything to renew it?
well, it didn't, it controls between the two leases. The first lease was in June of '83, and the second lease was in December of '83. And
Okay, that lease, okay, sorry.
yes.
Gotcha.
Yes, so the second December '83 lease controls where it's inconsistent with the first lease under the doctrine of merger. And the second lease, it was not renewed, and that's not disputed. So that leaves the appellant with claiming that the trial court erred at the trial and in the original judgment by failing to apply 4 affirmative defenses. And it's interesting, first, that of the 4 defenses, estoppel, laches waiver, and statute of limitations, 2 of them were not specifically pled, laches and statute of limitations. And when I went to try to prepare for argument today and going back through my brief, I found that I misstated in the brief that laches have been pled. That's a typo. It had not been pled, at least specifically. And none of them were really vigorously pursued in the trial court. The appellant's counsel, in closing argument, mentioned in brief that the court should apply a waiver or estoppel, but never really argued other than just mention it. So the appellee would contend that these affirmative defenses, number 1, have been waived. The 2 that weren't pled were waived because they weren't specifically pled, and that would be laches and statute of limitations. And the other 2 just weren't really pursued in the trial court. So they shouldn't be allowed to be pursued at the Court of Appeals. But putting aside the procedural issue about whether they were specifically pled or presented to the trial court, the record shows that they weren't applicable on the merits, any of them. On the estoppel issue, they say that we should be stopped from relying on the non-renewal of the lease. But this court said 25 years ago in a similar case, Hill versus Osborne, speaking through Judge Cesano, that estoppel at a minimum requires reliance upon a statement or actions of another person without opportunity to know the truth. And there can be no estoppel where both parties share the same means of ascertaining the truth. And in this case, the truth would be, how do you renew the lease? And in this case, the lease, which is Exhibit 4, expressly provides in paragraph 3, as I recall, the precise manner of renewing the lease. So Mrs. Partin cannot argue before this court persuasively, just as she couldn't have in the trial court if it came up.
So you're saying nobody relied on anything?
Nobody relied on anything, and there has been no misrepresentation by the property owners because the manner of renewing the lease is spelled out in the lease. Laches is an equitable defense, and it requires, in the same case, the Hill versus Osborne case, Judge Cesano explained, it requires an unexcused delay in making the claim and a showing that the defendant was injured in some fashion by the unexcused delay. Well, here there wasn't an unexcused delay because how this came up was through the lawsuit that we're on here today. Mr. Partin filed an answer and a counterclaim to it, asking the court to declare what rights, if any, the parties have under the leases of record. So he didn't delay, and the prior landowners didn't delay. This defense was asserted almost immediately as the defense to the present litigation. But moreover, even if there had been, theoretically and hypothetically, if there had been a delay, the reasons asserted by Mrs. Bryce to say that she was injured are just illogical, because she says that Robert Rankin died in 2013 and that he might have had some information about renewing the lease, but the lease renewal time period was the last few months of 2008. Robert Rankin died 5 years after that, and Robert Rankin had sold the sign business to the appellants 20 years before he passed away in 1993. They say also that Mr. Bryce, who is an attorney, is afflicted with dementia, and that he somehow, that has, because of his dementia, that has prejudiced the appellant. But the dementia has been more recently. It wasn't 15 years ago in 2008. And then they say that there was a fire that destroyed the Johnson records, the Johnsons who owned the northbound reed face of the sign. But that fire occurred just within the last couple of years, and there's no logical way as to how that fire could have prejudiced Mrs. Bryce. Waiver is the other defense, and on the merits on it, that might have provided the appellant a reed to hang on to in this case if the lease was different in its wording than it is now. If the lease was silent as to the time and manner or method of renewing the lease, then yes, our cases say that if the tenant stays in possession after the expiration of the initial term and pays rent at the renewal rate, then that would be a waiver of the landowner trying to claim that the lease was not renewed. But that's not the case here, because the lease specifically provides the time and manner of how to renew the lease, and that was not done, nor was the renewal rent paid. So there simply is no waiver, and as a matter of law, because the initial lease term expired, there is no lease other than a holdover tenancy. And then the last affirmative defense that was asserted on appeal anyway is the statute of limitations, and they've asserted the 6-year contract statute of limitations. This court in Green versus THGC explained that that statute accrues when the acts and conducts of one party shows an intention to no longer be bound by the contract. Well, that event occurred in this case when Mr. Partin sent 2 letters to Mrs. Bryce saying that basically you don't have a lease and I want you off the property. That was right before this case was filed. In fact, those letters were what provoked the present litigation. So there's not, the statute, if that statute applies, even though it wasn't pled, but if it applies, we were barely into the beginning of the 6-year period.
Why wouldn't we look at the statute of limitations from the beginning of, or the end of the legitimate lease?
You mean in 2008 when the first term expired?
2008. Why wouldn't the statute of limitations have begun then and run long ago before Mr. Partin ever even got the property?
Because, Your Honor, as this court has previously said, that statute accrues when one party shows an intention to no longer be bound by the contract. And that did not occur in 2008. That occurred in 2023 when Mr. Partin sent letters to the sign company, or the billboard company.
Okay.
Counsel, your time's expired.
Thank you, Your Honor.
We'll hear from the appellant in rebuttal.
I want to address first Judge Bennett, your question about what do we have here. If the lease really did expire in 2008. What's been going on all this time? The trial court found that Mrs. Bryce was a holdover tenant, and the tenancy was terminated by the defendant, Nathan Partin, on or around January 25th, 2023. That's when he sent a letter to them that essentially it didn't make an argument about the lease having expired in 2008. It just said, I hereby terminate the billboard lease. I want you off my property. So I do want to point out that if Mr. Cry is right, and that was a year-to-year contract, then the trial court's conclusion that it was terminated immediately upon giving notice in January of 2023, that has to be wrong, because a year-to-year lease is only terminable by giving 1 year notice. So I think what that would mean is that all the money that's been paid into court all this time, if the trial court was right, would have to go to Mrs. Bryce, because that would be revenue that would have come in during the 1 year notice period that had to be provided. The year-to-year lease, if that's what it was, couldn't have been just instantaneously terminated by Mr. Partin. On the issue of the defenses that were pled, all of the equitable defenses were pled in the answer to the counterclaim. Waiver and estoppel were specifically pled. Even though latches and the statute of limitations weren't mentioned by name, the statement in one of the paragraphs of the answer to the counterclaim asserted that Mr. Partin and his predecessors delayed and in fact did not institute legal proceedings, asserting non-payment and lack of consideration as bases for breach of contract for decades. That's essentially what the statute of limitations is. The answer didn't use the term statute of limitations or latches, but I think that that statement encompasses both of those defenses. Legal proceedings were
Make sure
not
I understand
instituted.
one thing, though. It's your position that the failure to pay the rent, the $10 a year, just means nothing.
Yes, that's our position,
That
because it was nominal
Your client could stay
consideration.
there would never breach by not paying the rent.
That's correct. That's
Interesting position.
We cited a case that said that if consideration is nominal, like in a deed where it says, I convey the property for $10, whether that $10 is paid or not is irrelevant. So our position is that applies here. The $20 a year or $10 a year, depending on what period you're talking about, whether it was paid didn't matter because it was nominal. It was essentially
It's
zero.
immaterial here, but what was the consideration your client gave then
In the initial,
in the 25-year lease?
at the very beginning, I don't think we know. That was between.
The only thing from the contract says is the $10 a
It's
year.
the $10 a year, that's correct, Your Honor.
And you're
But
saying that doesn't count.
I don't think it does because it was
So
nominal.
I'm just, like I said, I don't think anybody raised it or anything, but I just wonder what the consideration from your client was for the contract.
I don't think there's anything, that was between Robert Rankin and John Rankin at that time. I don't think we know. But the parties acted as though the lease were in force from 1983 all the way up until 2023, when this was brought. Thank you.
Thank you. Our court's thanks to counsel for both sides. We appreciate your arguments this morning and your briefs on this. If you would, recess court till 1:30 this afternoon, please. All rise. Y'all have a good day.